Yeah.
IDNR had put all the recordations stocked upon. It was a beautiful thing back in the 50s and 60s.
We're up.
Okay. Suddenly the beaver chewed lungs and there's no pond. Fix it. Glad I did. And other people do.
This phone makes it worse. 3 days later and I can't see anything. Okay, I'll call the meeting of the Zoning Board of Appeals of McHenry County to order. Our chair is not able to come today, so I'll take over for that. This is a continuance of petition, it is, right, a continuance?
Correct.
Yeah. Z725-0037. That was originally heard
On April the 17th.
April 17th, 2 months ago. Okay. And when we had that hearing, the board left with a bunch of questions that needed to be answered, and we have gotten most of those answers now, so we're ready to go on with this hearing. So, where's our, do we have to read the whole thing like we do normally? No, I just.
No, the legal sheet.
Just a minute if you want to.
So Vicki, just for clarification, go ahead and read what's in the sleeve there,
Yeah.
and then introduce the board, please.
Yeah, okay. All right, so this hearing is a continuation of the April 17th, 2025 hearing. Today's hearing date, time, and location were announced on the record at the last hearing date of April 17th, 2025. Therefore, notice by publication, certified mail, and posting were not required for today's continuation. We'll start by introducing our board members. And before we do that, I'd like to ask everybody to silence your phones if you have them with you. So we'll start with board introductions, starting with Mr. Cozen.
Robert Cozen, Algonquin Township.
Mary Donner, Greenwood Township.
Charlie Eldridge, Richmond Township.
And Vicki Gartner from Nunda Township.
Kurt Schnabel, Riley Township.
Jessica Beverly, Door Township.
Thank you. Okay, so. Now, if anybody is here today who was not sworn in at the last hearing to speak, and you'd like to speak today, please raise your hand and I'll swear you in. Do you swear to tell the truth, the whole truth, and nothing but the truth in your testimony?
I do.
Thank you.
We're glad to hear that.
Yeah.
One of these days, I'm going to outright lie to you, but
No,
not today.
no, you're a very honest person, we know.
Only if it lands on a Thursday, April 1st.
There you go.
There you go.
Okay.
Okay, so we received a packet recently that outlined the questions that we had that were answered. I should probably go through those a little bit so people are aware, right?
Would you like to go through that, or would you like me to go through this?
And you can go through that if you'd like.
Okay.
So we'll have your report now.
Okay. For the record, my name is Anna Kurtzman. I'm a senior planner here with McHenry County. As Ms. Gardner has indicated at the April the 17th, 2025 hearing, we did introduce the case for a text amendment for an overlay district on a portion of the Bayview Beach on the Fox River subdivision. Just a small name for that subdivision. Anyway, there were a number of questions that were raised. Some of them were legal questions, some of them were more technical in terms of the subdivision, and some of them were stormwater related. So this started out, just a refresher, that we had received a complaint about a pier being located on some property on the south side of West Beach Street, and that upon investigation we learned that piers were being erected in an area that did not have permits, In addition, they were being placed on property that, under today's zoning regulations, would not meet the legal requirement for a zoning lot. Piers, as a reminder, are considered to be accessory structures. So you need to have a principal structure that's either on the property or tied to property that is adjacent in some manner to the property where the accessory is occurring. Fast forward, some of these violations were taken to court, and this board asked for copies of the court materials. Those were quite voluminous. I gave you summaries of the proceedings, so that is attached here. You asked for a copy of the plat of subdivision. I gave you 11 by 17s and a couple of the full-size versions on the table there for your edification. You asked for a copy of correspondence between the planning and development staff and the state's attorney's office regarding the matter. I was not able to locate any documents specific to the overlay, other than whatever may have been through the court documents. Are there any restricted covenants which would mandate that ownership of the parcels in question be tied to ownership of properties elsewhere in the subdivision? The answer to that question is no. Who owns and maintains Beach Street? Nunda Township. Who would a person call if there was a problem with Beach Street? And it depends upon the nature of the complaint. It'd either be the sheriff's office or the Nunda Township. How did the assessor's office assign pens to areas with no land associated with them? So deeds just describe a geographic area, okay? It does not have to have land, just a geographic area. The assessor's office has to assign some sort of documentation as to identifying that property. So the assessor's office can and does assign pens for what we would question as being water, as long as there's some legal described area for that. Is the lagoon considered to be waters of the U.S.? The answer is yes. And just clarifying that the lagoon is also considered to be under the jurisdiction of the INDR. Two more questions here. What is the difference between the water level and the top of the seawall? I'm going to try to answer as best as I can because that's a little beyond my technical, but so your seawall is typically at the top of your high water line, okay? So they're basically one and the same is my understanding, okay? Hopefully that is
But that would be
useful.
the seasonal high water line?
Seasonal high water line, yes.
Yeah, so
Yeah.
anytime the water was lower than the highest it gets.
You'd have to step down. You'd have to
a
step
step down
down.
of some
Right,
sort.
right. That or step across onto the pier.
Yeah.
Okay. Okay, so your final question was a determination from the state's attorney's office regarding how the parcels were created and if they are legal. Again, I found no written determination from the state's attorney's office regarding the creation of the lots. Based on Renee's notes, and again, Renee Hanlon was our zoning enforcement officer when this process began. So she's not with us anymore. These are her notes. One is that the property owner created the lots legally via the Plat Act, then sold them to various parties. Through discussions, it was recognized that the initial property owner's ability to do so, that the state's attorney's office did successfully prosecute those that had violations, and that the lots without development are not subject to any violations. These lots as they've been created are insufficient for development. They don't meet today's zoning regulations and for creation of a legal zoning law. The vacant lots are okay to stay, but those lots with docks are deemed accessory structures without a principal use. And then there was two other notes. One was that primary theory was offered to achieve compliance to establish a conditional use permit for a marina for this area. If that were to occur, then this would make the docks a principal use. And then finally, the violations were not an acceptable solution because a use cannot be varied.
Okay, so the documents that, the text amendments that were created by staff are to address all these problems
Correct.
and to create a new type of overlay district to make all of these conforming.
So
that they are no
it
longer
would
in violation.
allow the accessory uses just for these to act. They are not principal uses, but act as principal uses.
Okay,
Okay.
okay. Does anybody have questions for Anna? No? Okay, then we may as well go ahead and start with that text.
Okay. So as a reminder, the proposed text is up on the screen. It goes onto two different screens here. Don't know. You went through last time. You got your questions from the audience and you got your statements from the audience last time. So you can at this point have your motion and discussion if that's what you want to do. However you want to proceed at this point.
Do you feel it's necessary to go through the text at all, or no?
You can certainly say, you know,
I'm
make a motion
frantically looking for
to
my
accept.
copy.
We've done that already.
So
Okay,
you can do a motion to accept the
Okay.
staff recommendation.
Can I make how do I make a proposal to amend the staff recommendations?
So my recommendation in that is go ahead and make the motion to accept staff's draft and then do this, just like you would amend a CUP. Then make a motion before adoption.
Okay.
I move acceptance of the staff draft.
Second.
okay. Okay,
Now,
discussion?
this would be your opportunity, Jessica.
I would like to make a motion to amend the staff draft. So just background here, before I make this motion, I talked to Anna a little bit about what it would look like. We heard a lot from the community about how they are self-policing this, they're a tight-knit community, they keep track of their own area, and the way that this is currently structured, like anybody could come in and purchase one of these. And so I would like to include text in the UDO that requires a deed restriction on these they must belong to somebody who lives within the subdivision. And I would suggest putting that into the overlay district UDO language. I don't want to do it because we have deed overlay restriction language in the UDO in other places, and I think to be cohesive, planning staff should just be able to pull that language and make it how they want it. But I would suggest that when this goes back to the PED committee, there be a deed restriction to only people who live in this community can own these properties.
So we have a motion. We need a second to that motion.
I'll second that.
Okay.
I don't know if Jess would be open to amending her amendment.
No, it's just a suggestion, it's just the process.
I think that requiring somebody to actually be living there is a bit restrictive. I would change it to someone who owned a residential, either a parcel with a residence on it or a parcel that was capable of having a residence built.
The only thing that concerns me with that amendment is that we've had Airbnb applications in the past, and we've already established how difficult those are to be policed in the county. And so I would suggest that limiting it to someone whose principal residence is on site would be a better self-policing tool than opening it up to someone who simply owned property or a lot.
What happens to someone for whom it's a second home?
That's a good question.
Yeah.
I mean,
Yeah, but it's a summer home. Or a place, I'm sorry, I did not ask. Bob had his hand up.
First, I'm unsure of how the county, and I wasn't aware, already utilizes the technique of deed restrictions in the zoning ordinance. And maybe Anna can give me just a little clarification of that. Because sometimes one tool in one location is more of a hammer than a fly swatter in another. The second thing is, I too agree that to continually to pursue a standard of ownership, greater detail, may create more complexities. Does the mother own it? Does the father own it? But just a generalized ownership would be sufficient from my perspective of establishing an interest in the property, rather than going down the chain of title of.
So are you,
That's fine.
you're referring to her amendment when you say
Right,
that? Okay,
right,
okay,
right, it's
understood.
a good one, but
Yeah.
my colleague, in terms of saying just ownership, I agree with that simplicity in it. But first, I'd like to just a general discussion of how the county uses the tool of deed in zoning.
Okay,
Okay. So the Unified Development Ordinance does allow when you have a an accessory structure that does not have a principal structure on the property, that you can do a deed restriction that would tie the accessory use to a principal as long as the two properties in question are either physically adjacent or across the street from one another. That deed is then recorded, and that deed restriction basically says that the two properties have to be sold together until such time as the accessory structure is removed.
so then second owners would automatically get that deed restriction as well.
Right, I'm going to title.
In this case, could you tie a deed restriction to a subdivision instead of a specific?
I would not recommend that because the subdivision is an entity that, in this case, would be hundreds of people that would have to sign each of those deed restrictions.
I understand, okay, it creates a problem. So for whoever owns these now, it would run with the deed to their home or property in the subdivision forever. They wouldn't be able to transfer just the dock to someone else like their neighbor.
Under your proposal, that would be correct.
And my proposal is consistent with what the county's already doing in the UDO. It's not something new or novel that we're writing up.
So the concept of doing the deed restriction is not novel. The novelty is that these piers, these properties, I believe are 100% owned by properties that are not adjacent.
but we could still do the deed restriction even though they are not adjacent.
If you add the amendment that Jessica has proposed. Now, her amendment does tie it to the people, if I understood correctly, as to opposed to your
Well,
suggestion.
I would be willing to amend it to tie it to another
Sure.
owned parcel
Okay.
within the subdivision.
Okay,
I'm just trying to wrap my head around like, then whoever owns these now, it runs with their home forever and ever, and they can't sell it or transfer it to their neighbor or anything like that.
so if they want to transfer it to a owner or to adjacent person or something like that, someone else in the subdivision, a new deed restriction would need to be filed. But it would be the same caveat that it would have to be the accessory tied to a principal somewhere in the subdivision.
Okay. Yes, I'm comfortable with amending it to ownership of a parcel within the subdivision.
Okay, so, did we have a second on that?
Yes.
Okay, then I'm going to,
So let's verify that.
I'm gonna,
Chris, did you catch a second for Jessica? Okay.
yeah, I actually wrote it down and forgot, so.
Okay, great, okay.
Okay,
excuse me, I just want to make sure. So what you're saying is, and what we are going to be saying is this overlay that has PIN numbers for property that's not attached currently to a particular owner. Let's say I've got a lot across the street, there's the lagoon. Now, we understand that one, if it's across the street from the lagoon and the lagoon, that because it's adjacent to or across the way from, that takes care of it. But what if I live on Louisa?
So with the amendment that Jessica has proposed, it would be handled the same way as across the street.
Okay, as long as that is, then my head's in the right, okay place.
So you could sell the pier, if you will, the pier parcel, you could sell to someone else as long as they were an owner in the
In the
subdivision.
subdivision.
In the subdivision,
Yes.
okay.
Yes.
Thank you.
Okay.
I have one question that's sort of related, maybe not, but are there other areas in the county that would be under the same type of situation where they would need this overlay?
So we have not identified any of that. I can't tell you that there isn't.
Okay,
Because I haven't looked at every property.
as I was
but-
driving around through this beautiful area, it seemed like I was noticing here and there may have been, you know, one or two piers on a
There's-
lot with nothing.
There are all sorts of strange things in
I
some
know.
of these old subdivisions.
Until somebody complains, oh well, right?
But in creating this overlay district, we resolve the problem here,
Yeah.
Yeah.
That's correct.
and nobody has to tear anything down, and nobody's gonna be in trouble anymore, and everything will proceed as it should.
Yeah.
Yeah, as it has.
Okay, so we need to vote now on the amendment.
Correct.
And,
Yes,
And
Okay.
then the overall.
and then we're on the overall. Okay, Mr. Eldridge,
Yes.
okay.
This is on the amendment.
Yes.
This is on Jessica's amendment.
The amendment as amended.
Yeah,
The amended amendment.
okay. What did I do wrong here? Who was it that seconded the initial motion?
I did.
Okay, thank you.
Charlie made it.
I made it.
Yeah.
And just made it, and I don't know who seconded Kurt.
On the amendment, I'm just gonna make a new column.
Sorry.
Okay. Mr. Eldridge?
Yes.
Okay, and Mr. Cozen?
Yes.
Mr. Schnabel?
Yes.
Ms. Beverly?
Yes.
Ms. Donner?
Yes.
And I will vote yes as well. That's 6 votes in favor of that amendment. Now, at this point, I think I need to break protocol a little bit and ask the audience if they have any questions before we vote on this.
So you did the question period during the
Yeah,
April the 17th.
okay.
You closed the question portion, I gave my report, and then you opened it
So-
up for the comments
You
at
can
that
inform
point.
Vicky,
do
this
it
goes
after
back
the
to
vote.
PED.
Yeah, right, but I thought maybe there was some input on this amendment and the overall thing that might be helpful. But we will move ahead, and we do have a motion on the text amendment as a whole with the amendment from Mr. Eldridge. We have a second from Ms. Donner, and I'll call the roll. Mr. Eldridge?
Yes.
Mr. Cozen?
Yes.
Mr. Schnabel?
Yes.
Ms. Beverly?
Yes.
Ms. Donner?
Aye.
And I will vote yes as well. So this again is 6-0 unanimously in favor of this new text amendment to allow
As
the
amended.
overlay district.
As amended.
As amended. As amended, thank you. Okay, is there anything else?
You can close the hearing.
I think that's it, okay.
Thank you.
Well, thank you all for coming.
Thank you.